Illegal tariffs are illegal. They are also taxes on Americans, and the president can't do that. Shockingly, the Supreme Court actually handed President Trump a defeat. In a strongly worded opinion, the court declared that President Trump's tariffs are clearly illegal. The court ruled that tariffs are a tax, that taxing power belongs to Congress, and that Congress had not delegated that power under the International Emergency Economic Powers Act, or IEPA. Too bad for this business owner who just wanted to give President Trump a big smooch on the derriere and thank him for his tariffs because he was able to raise his prices from $90 to $150.
And I said to the owner, I made a speech at a factory. They make steel products. And I said, how are you? Nice to meet you. How's business? President, I'd love to kiss you. This is a very powerful man. I don't want to be kissed by that man.
Now, the justices had slightly different takes on exactly why the tariffs were illegal, but in the end, even conservative justices Roberts, Gorsuch, and Barrett agreed that they were. Now, you probably remember that President Trump spent the spring and summer of 2025 forcing pretty much the entire world to ride the tariff roller coaster with him. He imposed massive, seemingly arbitrary tariffs on countries around the globe, then suddenly rolled them back, and then sometimes increased them again. He especially targeted China, Mexico, and Canada, but there were plenty of tariffs for everyone. Trump started with the so-called trafficking tariffs on China, Canada, and Mexico. These tariffs were supposedly payback because, according to Trump, these three countries weren't doing enough to stop the flow of drugs into the United States. And he toggled the exact tariff rates back and forth depending on how obsequious each country was that month. Sometimes the rates were as high as 145%. NAFTA, or the USMCA, notwithstanding. Next, he imposed worldwide tariffs, which he claimed were reciprocal tariffs designed to offset supposed trade deficits. That was incorrect. But the Trump administration claimed that these tariffs were proportional to each country's trade deficit with the United States, but the exact math was pretty fuzzy. And I cannot emphasize how dumb it is to base your tariffs off of trade deficit. I'll remind you that a trade deficit is not a malicious practice. It's just simply an imbalance between how much one country buys from us and how much we buy from that country. Most economists will tell you that a trade deficit is benign at worst. And there's absolutely no reason to punish that other country or Americans by instituting a tariff based on a trade deficit. Until James Surowiecki, a financial journalist, broke the code, proving the tariffs were pretty arbitrary, or as he put it, extraordinary nonsense. Needless to say, all the chaos made business planning pretty hard. So a group of small businesses filed suit, and a coalition of states soon followed. Now, the plaintiffs in the main case, VOS Selections, were a group of small businesses led by a wine importer. They filed suit in the Court of International Trade, which has exclusive jurisdiction to evaluate the changes to the tariff schedules that Congress set. Now, the small businesses claimed that the tariffs were devastating and were, as one business put it, quote, not survivable for a business of its size. According to the plaintiffs, though, the tariffs aren't only extremely harmful, they're also illegal. And the Court of International Trade agreed with the plaintiffs, and the case was quickly sent to the Circuit Court of Appeals, which, on its own initiative, agreed to hear the case en banc, meaning all of the judges in the Circuit Court of Appeals were going to hear it at the same time. Now, that's a privilege typically reserved for really important cases. And this was a very important case because it touched on serious separation of powers issues, but also because Trump's tariffs were having huge impacts not only on the economy, but also on international relations. In January, we covered Trump's push to take over Greenland. Tariffs were one of the tools that Trump supposedly used to try to force Europe to get out of his way, and he threatened significant tariffs on any country that opposed U.S. control of Greenland. Plaintiffs argued that Trump had violated the separation of powers by usurping Congress's power of the purse, because ordinarily under Article 1, Section 8 of the Constitution, Congress has the exclusive power to, quote, lay and collect taxes, duties, imposts, and excises. Tariffs are a specific kind of duty or impost. Now, Congress sets tariff schedules in what's called the Harmonized Tariff Schedule. The current tariff schedule was set in 1989, which does seem like a long time ago, but as the plaintiffs pointed out, the economy relies on having a consistent tariff schedule. Businesses plan on this because tariffs can have a major impact on business expenses, which is why the plaintiffs in VOS were suing. It's hard to plan ahead if you don't know if your tariffs are going to be 0% or 185%. But under some circumstances, congressional powers can be delegated, and the Trump administration argued that Congress had delegated its power to lay tariffs in IEPA. Once an emergency is declared under IEPA, the president has the authority to, quote, investigate, block during the pendency of an investigation, regulate, direct, and compel, nullify, void, prevent, or prohibit any acquisition, holding, withholding, use, transfer, withdrawal, transportation, importation, or exportation of any property in which any foreign country or a national thereof has any interest by any person. So when you take that paragraph and you strip away arguably the stuff that isn't relevant, the legality of Trump's tariffs turns entirely on the ability to regulate importation. And plaintiffs argued that President Trump had exceeded his lawful authority because the regulate importation language doesn't authorize the president to impose tariffs at all, let alone sweeping unlimited worldwide ones like the ones we're dealing with. Now, we've talked a lot on this channel about how the country is not slipping into authoritarianism. From a legal perspective, authoritarianism is basically already here. And that means that independent media is more important than ever. So if you'd like to support us on our mission to demystify the law as independent creators, a great way to do so is by signing up for Nebula, the sponsor of today's video. Nebula is a streaming service where you can watch all of the content from your favorite creators like Jetlag, Maggie May Fish, Real Engineering, PhilosophyTube, Real Life Lore, and of course, LegalEagle, all ad-free and early. I highly recommend you check out Lindsay Ellis's original documentary, The Macabre World of Police Body Cam YouTube. It's a fascinating expose on how this wildly popular genre of true crime content is altering social attitudes about the law and policing. And you can check out our exclusive videos on how to abolish ICE, the wild and forgotten attempts to ban booze in America, and how RFK Jr. can and cannot legally ban vaccines. In fact, every LegalEagle video we make is an extended cut on Nebula, like the legal analysis of improv comedy scenes that I did with Brennan Lee Mulligan, or my beatdown of Kim Kardashian's hilariously bad legal drama, All's Fair. Both contain a ton more insight and hilarious moments that we had to cut from the YouTube version. And if you use my link or code, you can get 50% off an annual subscription, or 40% the lifetime deal of Nebula. Either way, you can click or scan now to continue watching LegalEagle on Nebula, or I'll see you in court. But the Circuit Court of Appeals agreed with the plaintiffs that IEEPA did not give President Trump the power to institute reciprocal and trafficking tariffs. But the court was also careful to issue a narrow ruling and stated, quote, "We are not addressing whether the president's actions should have been taken as a matter of policy, nor are we deciding whether IEEPA authorizes any tariffs at all." The Trump administration freaked out and implored the Circuit Court of Appeals to stay its ruling while the administration appealed to the Supreme Court. Commerce Secretary Lutnick claimed that the ruling would, quote, "cause massive and irreparable harm to the United States and its foreign policy and national security both now and in the future." Treasury Secretary Dissent argued that it would lead to, quote, "dangerous diplomatic embarrassment," and Secretary of State Rubio claimed this could even hurt the Russia-Ukraine war negotiations. Now, the Supreme Court agreed to hear the case on an expedited basis, but granted the administration's request to stay the Circuit Court holding in the meantime. The court then consolidated the VOS selections case with a second case that had a more complicated procedural history. The other case was brought by Learning Resources and Hand to Mind, two family-owned educational toy manufacturers, which was filed in the United States District Court for the District of Columbia instead of the Court of International Trade. Now, while the Learning Resources case was arguably filed in the wrong court because the Court of International Trade has exclusive jurisdiction, most legal experts thought that at least the VOS selections plaintiffs would probably prevail. And on February 20th, that prediction came true. The court, including 3 conservative justices, handed down a stunning defeat to the Trump administration. Now, it's not clear why this couldn't have been decided a year ago before hundreds of billions of taxes were collected, but I guess better late than never. Now, the justices mostly differed on the exact reasons why Trump's tariffs were illegal, but Roberts, Gorsuch, Barrett, Jackson, Kagan, and Sotomayor all agreed that IEEPA does not grant Trump the authority to impose any tariffs. Now, it's not unusual for the Supreme Court to have a fractured majority. As here, John Roberts writes the majority opinion, but only the specific sections that are joined by 5, or in this case, 6 justices, is binding law. And here, 6 justices all agreed with the part of the opinion that the language of IEEPA does not allow the president to levy tariffs. Now, this opinion is noticeably broader than the Circuit Court decision in VOS selections. There, the Circuit Court specifically said that they weren't deciding whether IEEPA authorized any tariffs at all. They were only deciding whether it authorized Trump's particular reciprocal and trafficking tariffs. In comparison, the Supreme Court here is basically saying straight up, IEEPA does not authorize the president to impose tariffs, period. And in a rambling press conference given just hours after this opinion came down, President Trump simply could not wrap his head around this idea that IEEPA does not let him levy taxes.
But I am allowed to cut off any and all trade or business with that same country. In other words, I can destroy the trade. I can destroy the country. I'm even allowed to impose a foreign country-destroying embargo. I can embargo. I can do anything I want, but I can't charge $1.
Theoretically, the regulate language could mean that he could embargo and stop all trade with a particular country, which is debatable, but the statute as written does not allow him to levy any tariffs. And indeed, he was equally surprised that he couldn't even levy $1 or 1 penny in taxes, as a treat.
To show you how ridiculous the opinion is, however, the court said that I'm not allowed to charge even $1. I can't charge $1. Can't charge $1. I would have used 1 penny, but we don't make the pennies anymore. We save money. Can't charge $1.
Yeah, dude. No means no. Oh, yeah. Trump never learned that lesson. But at base, 6 justices agreed that tariffs are a tax, stating, quote, "Tariffs operate directly on domestic importers to raise revenue for the Treasury and are very clearly a branch of the taxing power. And only Congress has the authority to impose taxes. The founders, quote, did not vest any part of the taxing power in the executive branch. Therefore, the Trump administration was relying entirely on Congress's supposed delegation of congressional authority in IEEPA. But the justices held that this reading of IEEPA would be a, quote, transformative expansion of the president's authority over tariff policy that just isn't supported by the language in the IEEPA statute. And in a part of the opinion that I don't think any of the parties actually argued in their briefing, the court points out, if regulate did mean the president could impose taxes, then at least half of the statute would be unconstitutional because it specifically says the president can regulate importation and exportation, and the Constitution explicitly forbids taxing exports. So unconstitutional if you do, unconstitutional if you don't. But now we get to the place where the justices differed slightly in their analysis. The conservative justices, Roberts, Gorsuch, and Barrett, analyzed this question under the major questions doctrine, while the liberal justices Jackson, Sotomayor, and Kagan used basic statutory interpretation. As we've talked about many times before, the major questions doctrine is this thing that the Supreme Court made up around 2022 that's typically used by the conservatives who want to curtail agency or executive power to prevent democratic administrations from actually doing things. The idea is that under the major questions analysis, if Congress wants to delegate an especially consequential power, then it has to do so with especially clear and explicit language. According to the conservative justices, quote, these considerations apply with particular force where, as here, the purported delegation involves the core congressional power of the purse. Though it's telling that Justices Gorsuch and Barrett couldn't even agree what the major questions doctrine actually is. Is it a canon of statutory interpretation, or is it a actual general doctrine of the court? Nobody actually knows, and least of all these justices. And in a particularly Kaplan ball moment, Justice Kavanaugh actually wanted to create an exception to the major questions doctrine for, quote, emergency powers. I mean, it's all made up at this point. But in any event, the conservatives believe that any presidential power grab that involves taxes, especially a vast unilateral taxing power that's unpopular with a lot of people on the right, will get some extra scrutiny. And the president's invocation of IEEPA simply couldn't withstand that particular scrutiny. And the conservatives concluded that there was no historical precedent for these kinds of sweeping tariff powers, and that, quote, lack of historical precedent coupled with the breadth of authority that the president now claims suggests that the tariffs extend beyond the president's legitimate reach. But all of that major questions analysis is irrelevant because only a minority of the court even wanted to invoke the major questions doctrine. Without the liberals joining, it's just Roberts' opinion, not the binding opinion of the court. But the liberal justices also rejected the administration's claims about IEEPA, but for different traditional interpretation reasons. They signed on to the other portion of the opinion, which relied on traditional statutory interpretation and found that the president just didn't have the power based on the statute. In that section, the court, including Roberts, Gorsuch, Barrett, Sotomayor, Jackson, and Kagan, looked to the specific regulate importation language and found that it simply did not include tariffs, which are a form of taxation. They pointed out that IEEPA offers a lengthy list of other presidential powers, but includes no mention of tariffs or duties, which should be interpreted as a purposeful omission. If Congress meant to include tariffs, it would have. Ultimately, the six justices agreed that, quote, the president asserts the extraordinary power to unilaterally impose tariffs of unlimited amount, duration, and scope. In light of the breadth, history, and constitutional context of the asserted authority, he must identify clear congressional authorization to exercise it. IEEPA's grant of authority to regulate importation falls short. Alito, Thomas, and Kavanaugh all disagreed. Justice Kavanaugh, joined by Thomas and Alito, wrote a lengthy dissent arguing that IEEPA was designed to give the president broad flexibility in economic emergencies, and that flexibility naturally includes tariffs, and that if the court takes away the power, it could undermine the president's leverage in international negotiations. And Kavanaugh was also worried about the pragmatic consequences of having to return all this money. Basically, the bank robbers should continue to rob banks because it would be hard for the bank robbers to return that money. But during his press conference, Trump really liked Kavanaugh's dissent, which I'll remind you is just the words of one guy.
I'd like to thank and congratulate Justices Thomas, Alito, and Kavanaugh for their strength and wisdom and love of our country, which is right now very proud of those justices. As Justice Kavanaugh, whose stock has gone so up, you have to see, I'm so proud of him. But they didn't let us do that. I would like to thank Justice Kavanaugh for frankly, his genius and his great ability. Very proud of that appointment.
Which is fine. We sometimes read the dissents because we think that they are more persuasive, and he's entitled to his opinions. But by the end of the press conference, Trump was referencing the Kavanaugh dissent as if it were the binding opinion of the court, which it most definitely is not.
In actuality, while I am sure that they did not mean to do so, the Supreme Court's decision today made a president's ability to both regulate trade and impose tariffs more powerful and more crystal clear rather than less.
But Justice Kavanaugh did raise an important question. Now that the tariffs are unequivocally illegal and were from the start, does the United States have to refund the money that has already been paid? And Kavanaugh points out correctly that the majority is silent on that question. In his dissent, Kavanaugh noted that the, quote, refund process is likely to be a mess. But that's someone else's problem. There are no instructions for how or even whether to refund the tariffs in the majority opinion, and now it's been remanded back to the lower courts, I guess, to figure that out. Now, the fact that the majority didn't mention what's supposed to happen to these hundreds of billions of dollars that have been taken by these illegal tariffs is quite troubling. First of all, in the middle of this case in the lower courts, the Supreme Court issued a case called Trump versus Casa that is, I think, one of the most important and potentially destructive cases that this Supreme Court has ever issued. In that case, it basically destroyed the ability of lower courts to issue what are called nationwide injunctions. Something that used to be relatively universal practice was a lower court saying, hey, this nationwide policy or law is unconstitutional, and therefore I'm going to issue an order that prevents this law from going into effect across the entire country. Lower courts can basically no longer do that. Practically, the only thing they can do instead is to issue class-wide relief when you have a class action, which is way more onerous, and it's definitely not the same thing. So when Justice Kavanaugh says this might be really messy, well, it might be messy because of extremely recent Supreme Court precedents that might prevent the lower court from just dealing with all of this at once, issuing one order and saying, hey, just give this money back. So there's going to be a ton of unnecessary litigation in the lower courts to determine what can be done here. Is everyone going to have to file suit in order to get their tariff refund back? Yeah, maybe. And on top of that, one of the original trial court's decisions was whether to issue a preliminary injunction stopping the tariffs from going into effect while the courts decided whether they were legal or not. That was, of course, before Trump versus Casa came down from the Supreme Court. But one really interesting thing is that the government over and over again said, hey, you should not issue an injunction because if it turns out that these tariffs are illegal, we'll just refund all of that money. So there's a principle called judicial estoppel that theoretically might prevent the government from arguing now that they should not be required to issue refunds for everyone all at once. And a few credulous lawyers have said that this decision ushers in a new era of independence of the Supreme Court from President Trump. I don't believe that is true for a second, in particular because this court could have left the injunction of the lower courts in place and prevented the government from stealing hundreds of billions of dollars in the form of these tariffs. But instead, the Supreme Court left these tariffs in place while they took their sweet time to make this decision, which may mean that the plaintiffs get an extremely Pyrrhic victory by the end of this. Now, that answer may come relatively soon, though. Costco and several other companies have already filed a lawsuit in the Court of International Trade demanding tariff refunds. But this won't be the end of litigation on the tariff issue, especially since it looks like the president intends to continue to issue sweeping tariffs.
All national security tariffs under Section 232 and existing Section 301 tariffs remain in place, fully in place, and in full force and effect.
And he certainly doesn't want to give up the revenue willingly.
But other alternatives will now be used to replace the ones that the court incorrectly rejected. We have alternatives.
But that leaves open a ton of questions. Does this decision work retroactively to void all of the past tariff taxes that were paid? Will every single person and company who paid the taxes have to file suit to get a refund? And if they do, what venue? Will they have to file in the Court of International Trade? And can someone simply file the largest class action in history seeking $175 billion and just knock it all out at once? Now, despite the Supreme Court's very clear declaration that the president doesn't have the authority to unilaterally create tariffs under IEEPA, President Trump is putatively doubling down. In that rambling press conference, he declared victory and said, actually, the Supreme Court just handed him even more authority. He claimed authority to destroy entire economies, embargo countries, and to do, quote, anything that he wants.
But I am allowed to cut off any and all trade or business with that same country. In other words, I can destroy the trade. I can destroy the country. I'm even allowed to impose a foreign country destroying embargo. I can embargo. I can do anything I want, but I can't charge $1.
He then proclaimed that he was planning to impose a bunch of new tariffs under various statutes. He purported to levy an immediate worldwide tariff under Section 122 of the Trade Act of 1974.
Today, I will sign an order to impose a 10% global tariff under Section 122 over and above our normal tariffs already being charged. And we're also initiating several Section 301 and other investigations to protect our country from unfair trading practices of other countries and companies.
Though, even if he can, which would require an international payments problem, which we don't and can't have, that would only last 150 days, which he seemed completely oblivious to when someone asked him about it. And when asked if he was going to request from Congress additional tariff authority, Trump proclaimed,
"No, I don't need to, it's already been approved."
And then shortly thereafter, President Trump said the 10% tariffs are now 15%, just waving a magic wand. And I guess also says that all of the original tariffs are staying in place. You know, call me skeptical, but I'm not sure that the things that he's doing are legal, especially in wake of this decision. But I guess we'll have to do an entirely different video on what he can and cannot do as far as tariffs go. But businesses love uncertainty, right? Now, all this highlights why it's so important to get a great lawyer when you're dealing with your own case. Now, after I started this channel, every week I'd get hundreds of comments and emails from viewers who are dealing with legal problems. And they'd ask, can you help me find a lawyer? How do I know if this attorney is any good? And there's a massive gap in our justice system. It's that people don't know how to find the right lawyer for their specific situation. They're scared, they're overwhelmed, and they end up doing nothing or hiring the first attorney who calls them back. And that really bothered me. So I started to wonder, what if there was a different way? What if we could build a law firm that actually lived up to the values that I talk about on this channel? Transparency, accessibility, and putting clients first instead of chasing billable hours. A firm where you don't need to pay anything up front, and your lawyers only get paid if you do to maximize your opportunity for justice. So a few years ago, I decided to fix that problem. I decided to start my own personal injury law firm. And honestly, it wasn't an easy choice. But I realized I was in this unique position. I had this platform, this community, and the experience. Not to get rich, trust me, there are easier ways to make money than starting a law practice. But we did it because access to justice shouldn't be a luxury. Because finding the right legal representation shouldn't feel like playing Russian roulette with your future. And when you work with my firm, you're not just getting a lawyer. You're getting a team that understands that behind every case is a real person with real stakes. If we can't represent you or you're in a state where we don't practice, we'll take the time to try to match you with an attorney in my personal network of lawyers. A national network of some of the best lawyers in the country who actually specialize in what you're going through, located right where you are, not just whoever happens to be available. So if you're dealing with a personal injury, a car crash, a data breach, sexual harassment, a social security or workers' comp issue, give us a call at the number on screen or click on the link below. Now, I can't represent everyone that watches this channel. I wish I could, but what I can do is make sure that when you need legal help, you have somewhere to turn to that you can trust. So whether it's me handling your case or the incredible attorneys we partnered with, you'll get the same principles of honesty and education that we bring to every video. And if you're dealing with a legal issue and you're not sure where to start, check out the link in the description. Let's have a conversation about how we can help you find not just a lawyer, but the right lawyer for your situation. Because at the end of the day, that's what this is all about, making sure that when life gets complicated, you don't have to face it alone. Which is why when you need a lawyer, you don't just need a legal team, you need the Eagle team.